So hi, everybody. My name is Noah Chauvin. I am a counsel at the Brennan Center for Justice. And thank you all very much for joining us here today for this briefing on FISA Section 702, the votes that Congress will be taking in the coming weeks, and a new bill that has been introduced to reauthorize and reform Section 702. We have an additional panelist who might be joining us shortly. I sent him a message to make sure that he's still able to join, but we'll get underway now because I want to make sure that we're respectful of your time. Before we kind of launch into the substance here, just a couple of quick notes on programming. The first is we expect that we'll be talking probably around 40 to 45 minutes. With sort of prepared topics that we've come up with beforehand and information that we think is going to be particularly relevant to you as you're advising your bosses over the next few weeks on this issue. But we are booked for a full hour, and we want to make sure that this kind of time is useful for you. So please feel free to submit questions using the Q&A function, and we will make sure that we get those answered for you. I have it set up so that only myself and the panelists can see the questions as they're submitted. So, there's kind of no question too trivial. We want to make sure we're giving you all the information you need. So please feel free to submit those kind of as we're going through the presentation. We'll definitely have time at the end to go over them. The other note is I've had several people reach out and say that they wanted to attend the briefing but had conflict. So we are recording it today, and I'll post the recording afterwards. We'll turn off the recording when we get to the Q&A session again. We want to make sure that you have kind of all the information that you need. And I know sometimes people are a little uncomfortable to ask questions kind of on the record, as it were. And so we'll record kind of the substantive presentation, but then turn off the recording when we get the questions. So if you're watching this kind of after the fact and you have questions, please feel free just to send those to me by email or to contact any of the panelists. I'm sure we will be happy to get you the answers that you need. So with that, we'll get into the briefing itself here. And I'm going to start by introducing our panelists. I'm very excited to have a chance to talk with them today and to learn from them. And they bring a great deal of expertise to this issue and experience. So starting off with my boss, Liza Goitein. Liza is the Senior Director of the Liberty and National Security Program here at the Brennan Center for Justice. Before taking on this role, she held positions in all three branches of government. Next is Hamadanchy. He is a senior federal policy counsel at the ACLU, and prior to that, he had a number of roles, including in both the House and the Senate. So thank you to both of them, and I'll introduce our third panelist, hopefully, when he's able to get on. But we'll turn now into the substance. So, Liza, I want to start off with you and just kind of do some level setting for folks. I imagine they've all been kind of bombarded by our emails, but for folks who are sort of just coming up to speed on this issue, can you give us sort of a brief overview of what Section 702 is and why we're talking about it now?
Sure. Thanks, Noah, and thanks to everybody for joining this webinar today. Section 702 was passed after 9/11 to give the government greater power to conduct surveillance of suspected foreign terrorists. It allows the government to target almost any foreigner overseas and to collect all of their communications and other information without having to obtain any individualized court order. The FISA court conducts general oversight of the program, but it has no role in approving individual targets. Section 702 is scheduled to expire on April 19th unless it's renewed. And a lot of members have vowed not to reauthorize Section 702 without major reforms, in light of revelations that the FBI has regularly abused Section 702 to spy on Americans. Let me explain a little more about these abuses and how they happened. Because Section 702 authorizes warrantless surveillance, it can only be targeted at foreigners overseas. But the surveillance inevitably sweeps in enormous volumes of Americans' communications because Americans communicate with foreigners. The government refers to this collection of Americans' information as incidental. If it were otherwise, if the government's intent were to eavesdrop on those Americans, it would have to get a warrant in a criminal investigation or a FISA Title I order in a foreign intelligence investigation, which is another type of probable cause order. To prevent the government from using Section 702 as an end run around the Fourth Amendment, Congress did two things when it passed the law. First, it required the government to minimize the retention and use of this incidentally acquired information. And second, Congress required the government to certify to the FISA court on an annual basis that it's not using the program to spy on Americans. Despite these protections, all of the agencies that receive Section 702 data have procedures in place, which the FISA court has approved, allowing them to search through the data for the communications of Americans. So having certified that they're targeting only foreigners and therefore don't need to get a warrant, as soon as the data is in their hands, they start rummaging through it looking for Americans' information. This is a bait and switch that drives a gaping hole through the protections of the Fourth Amendment. The FBI conducted more than 200,000 of these backdoor searches in 2022 alone. And that pretty staggering number leaves no doubt that an authority intended to target only foreigners overseas has in fact become a very powerful domestic spying tool. Moreover, the FBI has engaged in what the FISA court called persistent and widespread violations of the rules governing these searches. These violations include some really alarming abuses, including searches for the communications of 141 Black Lives Matter protesters, members of Congress, more than 19,000 donors to a congressional campaign, multiple US government officials, journalists, and political commentators, and more. So this is why there is such an important conversation happening right now about the changes that have to be made in order for Congress to renew this authority.
Excellent. Thank you for that. And I just want to follow up on sort of one issue that you identified there, right? That the problems with this authority have caused a fair amount of outrage in Congress. But I'm wondering, right, bipartisanship can be kind of difficult to find in Congress these days, right? And so, is concern with Section 702 a strictly partisan issue? And if not, why not?
It's not at all. And the abuses that we've seen have kind of been equal opportunity offenders in the sense that there have also been baseless searches, tens of thousands of baseless searches of people who are merely associated with groups that were suspected of involvement in the January 6th attack on the US Capitol in cases where the Department of Justice and the FISA court said these searches should not have been permitted. So, tens of thousands of people involved in all kinds of civil unrest in this country have been improperly subject to these queries. And that's one of the reasons why we're seeing such broad bipartisan support in Congress for significant reforms. The major reform bills are all bipartisan and very much bipartisan, not just sort of a token member from one side or the other. So one of the bills that I'm sure we'll be talking about, the House Judiciary Committee's bill, the Protect Liberty and End Warrantless Surveillance Act, was co-sponsored by Representatives Chairman Jordan and Representative Ranking Member Nadler of the House Judiciary Committee. That's not a pairing you often see. And it passed out of the committee on a 35-2 vote. So this is absolutely a bipartisan issue, more so than almost any issue that I have observed in Congress over the last 20 years.
Thank you for that. That's very helpful. And it's something that's been almost kind of cute to watch in sort of public statements and hearings about the bill to see Representatives Nadler and Jordan. They just seem so amazed at kind of how much agreement there is on the House Judiciary Committee about their bill.
Enjoying it. It must be a relief.
Yeah,
change.
indeed. Well, that's excellent. Thank you very much. So Kia, Liza kind of previewed some of this, but I want to turn to some of the bills that have been actually introduced to reauthorize Section 702. We've heard that it expires on April 19th. By my count, there are currently kind of 6 bills that are sort of actively under consideration to reauthorize the authority. In each case, the kind of sponsors of the bill say that it enacts meaningful reforms. In your view, is that a fair characterization of each of these bills?
Unfortunately, no. I mean, I would say 3 of those bills, I think that is an accurate characterization. I would say 3 of those bills, it isn't. And so I'll briefly kind of run through all 6, kind of from strongest to weakest. And the strongest bill is the Government Reform Surveillance Act from Senators Wyden and Lee. And it really gets at every single issue that reformers have wanted to see changes on. It fixes the warrant rule. It fixes Executive Order 12333. It ends the data broker loophole, and it makes important changes to judicial oversight. And if I could maybe wave a magic wand and pass a bill, that would be the one that I would obviously try and pass. The next bill, which is the Protect Liberty Act, comes out of House Judiciary, also a very, very strong bill. It ends the backdoor search loophole. It also ends the data broker loophole, and it makes important changes to the amicus process, which we think those are all really, really meaningful reforms, and it would be great if Congress passed that bill. The third bill, which Senator Durbin and Lee introduced, I believe last week, is very similar to Protect Liberty. It's a little more of a compromise bill, which we'll talk about more later in terms of how it structures the backdoor search loophole fix, and it also just how some of the language it uses around how it fixes the data broker loophole fix. The fourth bill, RISA, which is kind of a compromise package between House Judiciary and House Intel. This falls in the category of bills that doesn't meaningfully reform 702. What basically had happened before was that there was a process where House Intelligence and House Judiciary were going to get together and they were going to agree on all the things they could agree on, and they were going to have an amendment process for all the things that they didn't agree on. So RISA on its own isn't really a reform bill. The idea was this is the base that we're going to start on, and each side is going to have 3 amendments that they want to see. And the amendments from House Judiciary are the things from Protect Liberty that we really would consider meaningful reform. So on its own, RISA it does not reform much. In fact, and in some instances, specifically with the amicus provisions, it actually makes things worse. The fifth bill is the bill it's the FISA Reform Reauthorization Act out of the Senate. This essentially, 2 things about this bill that I think are important. One, it codifies changes the FBI has already made, and which have been not shown to actually fix a lot of the problems that we've seen with 702. The other thing that I would note about this bill is it has a 12-year reauthorization, which is longer than we've ever seen for 702, and would mean that we don't come back to this program for another 12 years. And the last bill, and I think the bill that we view the most problematic, is the House Intel bill, which has a lot of the same provisions as Senate Intel, but there's 2 other provisions that I think make it more problematic. One is Section 504, which redefines the definition of electronic communication service provider and brings in all sorts of other businesses potentially under 702. So potentially you could have hotels, coffee shops, libraries, anyone with a Wi-Fi could now be forced to turn over their communications under 702. The second thing about House Intel bill is it has a consent exception for searching just the communications of members of Congress in order to do it for a defensive search. So essentially, if the intelligence community wanted to do what they call a defensive search for a member of Congress, they would have to ask their consent to do so. This would not apply to anyone else other than members of Congress. And so we think that sort of section, we support a consent exception for all Americans, not just members of Congress. And I'll turn it back over to Noah.
Excellent. Thank you for that. That's very helpful. I want to turn now to the SAFE Act. This is the bill, as Kia mentioned, that was recently introduced by Senators Durbin and Lee to reauthorize and reform Section 702. So, Liza, go back to you here. So the full name of this bill is the Security and Freedom Enhancement Act, SAFE Act. It's a good acronym. Can you tell us a little bit about some of the major features of this bill and kind of how it's different from some of the other ones that have been introduced?
Sure, I'd be happy to. And I think it's important that we spend some time focusing on this bill because the other bills that were introduced a little earlier in the process, we've talked about in other webinars and other places that you can see, that you can access, but we haven't really had a chance yet to talk to all of you about the SAFE Act. So I'm going to spend a little bit of time on it. Please bear with me. The first thing that the bill would do is to close the backdoor search loophole by requiring the government to obtain a warrant or a FISA Title I order before accessing the content of Americans' communications that have been obtained under Section 702. This is a little different from the other two actual reform bills, the GSRA and the Protect Liberty Act. Those bills would require the government to get a warrant before searching the Section 702 database for Americans' communications. The SAFE Act, by contrast, allows the government to perform the search without a warrant. But if the search then yields a hit, in other words, if it returns communications to or from or mentioning that American, the government then has to get a warrant before accessing the content of those communications. And the idea there is that the vast majority of backdoor searches aren't going to generate a hit. They don't generate a hit. And so this saves the government the trouble of getting the warrant in all of those cases where nothing is returned. Like the GSRA and the Protect Liberty Act, the warrant requirement in the SAFE Act includes exceptions for exigent circumstances, for consent, which is relevant in cases where the search is being performed to try to identify and protect potential victims of foreign plots, and also for certain cybersecurity related queries. Now, according to the Privacy and Civil Liberties Oversight Board, the government has provided little justification, that's their words, for the national security value of U.S. person queries. In other words, collecting and reviewing foreigners' communications under 702 has had tremendous value, but U.S. person queries, not so much. However, in the few cases where U.S. person queries have proven useful, the board noted that the government could likely have either gotten a warrant, obtained the consent of the subject of the search, or invoked the exigent circumstances exception. So, in other words, those queries could have taken place and the contents could have been accessed under the SAFE Act. I want to stress that the notion of a warrant requirement for U.S. person queries is neither new nor radical. In 2013, a panel of experts appointed by President Obama, including former acting CIA Director Michael Morrell and President George W. Bush Chief Counterterrorism Advisor Richard A. Clarke, unanimously recommended this measure, a warrant requirement for Section 702 queries. The House has twice passed such a requirement, and in a recent poll, 76% of Americans supported requiring the government to get a warrant to search international communications for Americans' information. So the SAFE Act also closes the data broker loophole, which Kia referred to, under which the government is evading statutory and constitutional privacy protections by purchasing massive databases of Americans' most sensitive information from data brokers. And I want to give you one quick example so you know what we mean when we talk about the data broker loophole. The Electronic Communications Privacy Act prohibits phone and internet companies from sharing sensitive customer information with the government unless the government has a warrant, court order, or subpoena, depending on the type of information. But this law, the Electronic Communications Privacy Act, doesn't apply to digital data brokers because they didn't exist in 1986 when the law was passed. So companies that are prohibited from selling your data to the government can sell it to data brokers. And those brokers can turn around and sell the very same information to the government. So the data is basically laundered through a middleman. The SAFE Act would close this and similar gaps in the law by prohibiting the government from purchasing information that it would otherwise need a warrant, a court order, or a subpoena to obtain. It's a little different, though, from the data broker provisions in the Protect Liberty Act, because it allows the government to purchase a data set if it can't determine in advance whether that data set includes Americans' information. As long as the government follows strict rules limiting U.S. person queries of the data sets and requiring the destruction of U.S. person information when it's detected. Closing the data broker loophole is extremely popular in Congress and with the American people. The Fourth Amendment is Not for Sale Act, which is one bill that tackles the data broker loophole, passed out of the House Judiciary Committee unanimously last July. And in the poll that I mentioned earlier, 80% of Americans supported this reform. Finally, and very quickly, the SAFE Act adopts what's known as the Lee-Leahy Amendment, and that's a set of reforms that improves the workings of the FISA court, largely by strengthening the role of amici, so that the court hears perspectives and facts other than those presented by the government in more cases. These reforms that in the Lee-Leahy Amendment, they were offered as an amendment in the Senate in 2020, and they passed by a vote of 77 to 19. The SAFE Act includes various other provisions designed to enhance transparency and accountability and to prevent abuse, but I've covered a lot of ground, so I'll just stop there.
Excellent. Well, thank you very much. That was very, very helpful to give us a picture of this bill. So Kia, you spoke to us earlier about kind of the range of bills that have been offered to reauthorize Section 702 and gave us kind of a sense of how far apart, right, that members who are kind of concerned about Americans' privacy and surveillance hawks are when it comes to thinking about if and how Section 702 should be changed. So in their press release, kind of announcing the introduction of the SAFE Act, Senators Durbin and Lee described it as a compromise bill that takes a pragmatic approach. In your view, is that an accurate description?
Yeah, I think it is. I mean, if you look at when talking about the Senate, Senator Wyden at one end of the Senate, and then you look at Senator Warner's bill at the other end of the Senate, Senator Durbin and Lee, they really did try to craft a bill that was kind of a middle ground between both. It actually takes pieces from both bills, right? There are provisions from Senator Warner's bill that do make it into the SAFE Act, and similarly, there are provisions from Senator Wyden's bill that make it into the SAFE Act. And also, there are provisions from Senator Wyden's bill that the ACLU very much supports that didn't make it into the SAFE Act. That's reforms to 12333. Stuff like standing, state secrets, parallel construction, even the modification of the warrant rule that now making it now apply to accessing the contents of the search versus actually at the point where you have to make the search. That's a big compromise for in terms of kind of where we started to where we are now, and that's not to say that it doesn't have strong reforms or that's not a good bill, because it is, but there was definitely a lot of things left on the cutting room floor, as happens with any compromise, and this is a really strong attempt by Senator Durbin and Senator Lee to try to craft a bill that can get 60 votes in the Senate and actually become law, but which also addresses some of these fundamental problems with Section 702.
Excellent. Thank you for that. I want to turn next to Alex Marthews. Alex is the national chair at Restore the Fourth and has had a distinguished career in civil society. Alex unfortunately had some kind of technical issues joining us at the outset because apparently he's sending my emails to spam. But we've fortunately gotten it resolved. So Alex, we've heard kind of about sort of the substance and the policy related to the SAFE Act. We've heard about how Senators Durbin and Lee really wanted to make this, a compromise bill that sort of, accommodates concerns from, sort of both extremes when it comes to reauthorizing Section 702. But I want to ask you kind of the political question here, right? Which is, can the SAFE Act garner the votes necessary to be enacted by Congress?
Well, I think that is a really useful question to be asking. I think, unsurprisingly, that the answer is yes, but this is the analysis here. It has been very possible in the long course of these debates over the government's surveillance powers to take extreme and purist positions. There are folks on the Hill who want to see a straight reauthorization of the existing powers, no matter what the stream of abuses that has been uncovered. Because for those few people, Section 702 is working exactly as designed, and there's not a problem with it if it conducts hundreds of thousands of searches on Americans every year. That's an extremist position. In a similar vein, there are legislators on the Hill who have said that they want to see Section 702 lapse entirely or to see FISA lapse entirely because of their level of discomfort in the ways that the government has exploited and abused these powers. That is also an extremist and purist position. I would note that the bills coming out of the Intelligence Committee, as Kia has helpfully described, are really pretty purist. They are really straight reauthorization with a little fiddling around the edges. The SAFE Act is the bill that is intended for legislators who want to know that people have thought carefully about this issue, that there has been careful consultation with the administration and with a multiplicity of voices as to what they think will be feasible and what they think will not be feasible. And there are certainly aspects of the SAFE Act that give us some concerns as a civil liberties group, because we are meant in some senses to be more purist than staffers in Congress and legislators themselves. But it is careful, it is trying to take account of the political realities, it is trying to give folks a way to demonstrate clearly that they are addressing this issue in a thoughtful and responsible way. And for offices for whom that is the key legislative value, I think this will be a very attractive prospect.
Excellent. Thank you. That's very helpful. And I think quite hopeful that there's sort of a realistic prospect here of getting substantial reforms enacted.
I think what we've seen, Noah, if I just sort of add a little bit, is that certainly relative to a few years ago, there is a much stronger bipartisan consensus among reformers. There are many more people who are interested in the topic from both the left side of the aisle and the right side of the aisle. And that is one reason why we are seeing productive reforms coming through like this, instead of what tended to happen before, which was Congress being put to the last minute on whether anything would happen over Section 702 and then getting bounced into something that looked very like a straight renewal. The SAFE Act is what you do if you don't want to be rolled in that way.
Excellent. Thank you. And that's a really good segue into sort of the next area that I wanted to cover here, which are the votes that we expect to be happening in the next several weeks here. Right? So we've mentioned that Section 702 expires on April 19th. So if Congress doesn't act, the law will kind of go away. And so, Liza, Speaker Johnson has told the press that the House is going to vote on whether to reauthorize Section 702 when Congress returns from recess the week of April 8th. Do we know which of kind of the 6 bills that Kia discussed earlier he's likely to bring to the floor?
We really don't know for certain, but one possibility that he has indicated is that he might at least start with the Reforming Intelligence and Securing America Act, or RISA, which I believe is the 4th bill that Kia discussed, starting with the 3 bills that actually reform Section 702 and then moving down to the 3 bills that really don't. And RISA is basically a kind of Frankensteinian creation that supposedly represents the areas of agreement between the House Judiciary Committee and House Intelligence Committee. But because these committees fundamentally disagree about whether real reform is needed, RISA itself includes no significant reforms. The idea was to have an amendment process. And RISA itself is actually much closer to the HIPSI anti-reform bill than it is to the House Judiciary Committee's reform bill. RISA's leading reform, and I'm using air quotes on purpose, is a prohibition on backdoor searches performed for the sole purpose of finding evidence of a crime. In other words, with no foreign intelligence purpose. That might sound like a significant change until you realize that the FBI almost never conducts these evidence of a crime only searches, or at least doesn't label them as evidence of a crime only searches. In 2022, a year in which the FBI conducted 204,000 backdoor searches, this prohibition would have stopped the FBI from accessing Section 702 data in exactly 2 cases. This prohibition would not have prevented any of the most egregious abuses, the searches for Black Lives Matter protesters, members of Congress, 19,000 donors to a congressional campaign, etc., all of which were purportedly intended to find foreign intelligence. The bill's other reforms, more air quotes, relating to backdoor searches, mostly just codify changes that the FBI has already made to its training, supervisory approval, and systems access requirements. But those changes have proven to be insufficient. After the FBI implemented them, the government continued to report FBI violations at a rate of 4,000 violations per year, including searches for the communications of a US senator, a state senator, and a state court judge who had contacted the FBI to report civil rights violations by a local police chief. In terms of oversight and accountability, the bill actually weakens the role of FISA court amici, and therefore weakens FISA court oversight by limiting the issues that amici are allowed to raise in FISA court proceedings. That's pretty astonishing given the well-documented problems with the FISA court and the widespread consensus that the role of amici needs to be strengthened. And the last thing I'll mention is that the bill, much like the HIPSI bill, in fact, it's the same, I think it's the same provision that Kia had mentioned, gives special treatment to members of Congress, requiring notification and consent for certain queries of lawmakers that are not required for ordinary Americans. So I would put this in the category of an anti-reform bill, similar to the proposals of the House and Senate Intelligence Committees. And if it were offered without any opportunity for amendments, that would be a real travesty and a real betrayal of Americans' trust, given the overwhelming support among the American population for real reform.
Thank you. That's a very helpful overview. And I want to turn back to the kind of opportunity for amendment in a moment. But before we get there, so Kia, Liza's described how RISA embodies sort of the least common denominator, right? That sort of the House Judiciary and HIPSI Republicans could agree on, which doesn't amount to all that much. And so we're talking about a bill that would make relatively little meaningful change to the law. Do you think a bill like that would be able to pass the House?
And to not just make little change, in some instances, with the amicus, it would make things worse. But no, I'm skeptical that such a bill would be able to pass the House. I think you got to remember that this bill on its own was never meant to be enough, right? This was just, these are the things that we agree on, obviously between the two sides, and then there was a series of 3 amendments, and the whole part of the deal was we can agree to this base text as long as the House has the opportunity to vote on these amendments, right? And without the opportunity to vote on the reforms that reformers think are meaningful, a bill on its own that doesn't fix any of the problems with 702 has I think very little chance of passing the House, especially because it would almost certainly have to move on suspension. And so we're not talking about a majority of the House, we're talking about asking 2/3 of the House to vote on a bill that doesn't actually fix any of the problems with 702. And given everything we've seen from both Republicans and Democrats this year, given the appetite from reform from people across the political spectrum, I am deeply skeptical that a bill like this could get 2/3 of the House to vote in favor.
Excellent. Thank you for that. So I have one more kind of prepared question here, but I want to make sure we have an opportunity to answer audience questions as well. So folks, if you have questions that you'd like us to answer that we haven't gotten to yet, please feel free to drop those in the chat and we'll get to them shortly. Like I said before, it's only myself and the panelists who'll be able to see who has asked a particular question, and we'll turn off the recordings before we start.
No, you said to drop it in the chat, but it's the Q&A function, right?
Yes. Thank you. Sorry. Yes,
no worries.
if you put it in the chat, other people will be able to see it. So please put it in the Q&A box. My apologies. Okay, so the last kind of issue I wanted to talk about, this is something that Liza and Kia both touched on, right, is the need to have an opportunity for members to vote on sort of meaningful reforms, right? The RISA kind of base text doesn't have. So, Alex, I'm wondering, if it's sort of RISA and that's the base bill, and there are votes on amendments, or if it's the SAFE Act, or another vehicle, right? One of the ones that's already been introduced, or a new bill that might still be kind of yet to come. What would you say are sort of the minimum reforms that members must be afforded an opportunity to vote on before April 19th?
Thank you, Noah. So first I should echo a little bit of what Kia is saying, in that it is weird to have rumors out there of RISA being brought to the floor, because RISA doesn't have a constituency just considered in of itself. There's no body of people who are going, hooray for RISA, this is what we want to see. The bill that is, I think, best in line with where a majority of Americans are in the polling, and that is also best in line with where the median member of Congress in each chamber is unquestionably the SAFE Act. If there were a world where we see RISA brought to the floor in the House anyway, then we don't see that we would be able to support it unless it had three minimum elements to it, which I think would fundamentally change the nature of the bill to make it more like the SAFE Act. One is that, as Kia has also alluded to, the amicus provisions in RISA are profoundly damaging and seem to be structured to try and prevent any actual pro-civil liberties voice or person with a background that is not in the intelligence community from serving as an amicus on the FISA court at all. The appropriate language which represents best where Congress is at is the Lee-Leahy reforms that Liza referred to, that garnered 77 votes in the Senate when they were voted upon in 2021, that are incorporated in the Protect Liberty Act, that are incorporated in GSRA, that are incorporated in the SAFE Act as well. They are good measures that try to balance out the very unbalanced process at the FISA court that has led to, in most cases, there being an entirely one-sided, non-adversarial process when deciding whether someone or some set of people ought to be surveilled. So that's one element of this. The second element is that I don't think that a bill is viable unless it contains a meaningful warrant provision. And meaningful not meaning the text that is in the House Intelligence or the Senate Intelligence bill, because as Liza was also talking about, that alleged warrant requirement would cover a really minuscule proportion of the problematic queries that have led to abuses.
And actually, just to jump
Well,
in, Alex, that's not even a warrant
yes.
requirement, right? That's a flat prohibition on those queries.
Yes.
But the reason they were willing, because they're not willing to do a warrant, the reason they're willing to go further and do a flat prohibition is because it doesn't affect any actual queries. It's a prohibition on queries that never happen. Anyway, so go ahead, Alex.
A purely ceremonial set of language there. So the warrant language that is in GSRA or the Protect Liberty Act is strong and appropriate and would help to resolve the abuses that we have seen, but by providing adequate protection for US persons' privacy where their communications have been swept up in what was, after all, originally billed as a foreign intelligence program targeting non-US persons who had information of interest for foreign intelligence purposes. That is a provision that would bring this whole structure back closer to its original intent. And that would be an appropriate thing. And that is why you are seeing very broad support for that kind of language from the public and from so many members of Congress. And the third element is there cannot really be a meaningful reform that does not include a meaningful protection from commercial exploitation, government exploitation of commercially collected data. Because if you have a warrant requirement in there and you don't have a data broker provision, the data broker provision under any form of the text would by default require government agencies to get a warrant to purchase data that would require a warrant if they acquired it directly. You don't have that in there, and it's effectively a non-reform because all the FBI then needs to do, or all another querying agency needs to do, is to go and purchase these kinds of data from the massive and exploitable commercial data sets that we know are out there, and where there has been a continuous stream of scandals of government agencies who have been exploiting that newly available commercial data to the hilt. So we do need meaningful reforms here. Meaningful reforms are popular. And as I say, there has been a deal of thought going into what that would look like and what would be appropriate and workable. So there are reasons why all of these elements, these three elements, are significant in the context of these reforms. As Keir says, during the course of this, there are a number of things that pro-civil liberties folks have left on the table. And we have been negotiating in good faith with members of Congress and having discussions with leadership and having discussions with the administration. Meanwhile, it appears very much from where we are standing as if there has not been a similar flexibility encoded in the legislative products that the Intelligence Committee committees have been putting out.
If I could just add briefly on that point, Alex was talking about how the SAFE Act sort of represents, a compromised position, and that's true. The Protect Liberty Act also represents a compromised position. I think that's important to understand. We started with the GSRA, the Government Surveillance Reform Act, which was the Wyden Lee bill, and it was a Davidson-Lofgren bill in the House. That's the strongest bill out there. The Protect Liberty Act the full title is Protect Liberty and End Warrantless Surveillance Act. That's very clunky, so we're calling it Protect Liberty Act. That was introduced by the House Judiciary Committee as a compromise, and there were some painful cuts to make that. So I would say, both Protect Liberty Act and SAFE Act represent, and then SAFE Act compromises yet a little bit more. But either of those are compromise, very reasonable, sensible compromise bills that are going to protect privacy and national security. And those would be far better places to start than RISA. But if RISA is brought to the floor, it has to be with the opportunity for the exact amendments, for the amendments that would put in place the reforms that Alex just described.
Excellent. Thank you both for that. And Liza, I know you and I wrote when the GSRA was introduced about how even that didn't do kind of everything that we hoped it would.
It was close. It was close, though.
It was. Yes, it was a really excellent bill. You know, I'd be inclined, if I was feeling a little facetious, to call that a compromise bill as well. Well, thank you very much to our panelists here. This is all excellent and informative. I'm going to turn off the recording now. So if you're kind of watching this on pay-per-view, we're going to end it here. But if you have any questions, please feel free to send them in to me, and I will make sure we get them answered for you.